Ian Hull, thank you so much for joining me. You're a real leader in the estates bar. I've been following you for years, and without your contribution to the estates community, I think we'd all be in a worse off position. You were called to the bar in 1990, and you founded Hull Hull in 1998, and it's since grown to really the leading firm, estates firm, I think, in Ontario. So much so, there's Facebook groups with estates lawyers, and people ask questions there. And people bring in different sources, and I would say the blogs from Hull Hull have the weight of almost statutes. People post them, and that really ends the conversation. So there's the output that you give, and the teaching. I also try my best to attend your weekly classes on Thursday, and there's also I end them obviously with some knowledge gain, but a feeling of, oh, there's so much more I wish I could hear and learn from you. And it brings me back every week, so to speak. And again, the mentorship that you give the younger lawyers is really unparalleled in the estates community. Just a personal background I like to ask is how you came to study law, and what happened before your call in 1990. What really prompted you to pursue this career?
Well, thank you for all those kind remarks, and it's a real pleasure to be here, and thank you for having me. What really I started to pursue the idea of getting into law was I was a history major, and I went to Western and enjoyed history, but I wasn't sure that I could take that on as a career choice. I had a father who, I'm one of 5 kids. I had a father who was a lawyer, and none of us were all that interested in law throughout growing up. But I sort of morphed into it, and like many of us, unfortunately, at the end of your first degree, you sort of look around and you wonder, what am I going to do next? And law was an option, and I was lucky enough to get into law school and never looked back.
Mm-hmm. And then what did you do after law school? I mean, regarding articles, and you called to the bar in 1990. From 1990 to 1998, what kind of experiences did you have?
Sure. So I first had great opportunity. My first job was 2 years working at a firm called Koski Minsky, worked in the construction litigation department and did commercial litigation work. Really got exposure to the world of litigation. I would say a rough and tumble world. The construction lien work is not for the faint of heart. You're constantly counting the number of days to make sure you haven't missed a lien period, and it's pretty high stress work. But having said that, I worked there for 2 years, and then my father was counsel at a firm in downtown Toronto doing estate work. He'd been doing it since the 50s, but I thought, I enjoyed the litigation, and he was on his own and came to me and said, look, why don't you come work for me? After 2 years of litigation experience, I realized I wanted to stay litigating, and what a great opportunity to work with my dad. So in 92, I started working with my dad until he passed away. So I had almost 20 years working with my dad, day in and day out, enjoying, just the learning that I got and received from him is pretty special. I mean, a father-son is pretty neat, and I got an opportunity to learn from a different lens, but it was fantastic.
Mm-hmm. That's really incredible, the importance of mentorship, so to speak. I must just say that my intro remarks were very abbreviated. You're an author of many books, and I mean, when I was doing my rounds with the different estates law firms in Toronto, I discovered that in one way or another they all originated from Hull and Hull. So what's your feeling about that?
Well, I'm very proud of our firm, but I'm also proud of those who want to do what they want to do. And I was lucky enough to work with my dad and work up a practice area in a boutique environment, and thrive and enjoy my work every day. So although I love all of the people I work with, I also appreciate and respect people who want to try different opportunities and different entrepreneurial aspects of the law. So yeah, we've had some great opportunities to work with people who have then gone on to create their own firms, and yet we have saw some real long-term lawyers with us too that I've worked with. One of the lawyers I worked with back in the Koski-Minsky days. So I've got a long history within the firm and also growth around the firm.
Right, it's really incredible, and I mean, people who spend time at Hull and Hull are known to really be experts in a way. So, can you talk about the importance of mentorship? You mentioned your father mentoring you, and also mentorship the younger generation of lawyers. Now that you're a mentor yourself.
Yeah. Well, it's true. I got mentored by a very special person in my world, of course, and he started off. I was lucky. I mean, there wasn't the economic pressures because when we first started, he had lots of work and passed on lots of it to me, but also expected me to be asking him questions. Basically, said to me in the first 2 years, don't talk in a meeting and listen and learn. And would leave the meeting and we'd have great discussions. I used to drive him to and from work, and not because I wanted to work those hours, which were great hours, but I had young kids and we'd talk the whole way there and back, and that was little things like that. But I use that as an illustration because mentoring people who have the experience and the knowledge, I always say to people, look for opportunities to soak the information out of them instead of just the conventional 9 to 5 period of time when people are frantic on phone calls and meetings and so on. Maybe pick an opportunity like that. I mean, obviously driving your dad back and forth to work doesn't work for everyone, but it's one of those things that the mentorship, people like you as I do, we like people, we like working with people, and we love giving mentoring guidance if asked. It's just a question of finding the time and energy, and sometimes. But mentoring is such a profound part of the law that, for me anyway, what good is it to me to just sit down and put my head down and act for clients and quietly come home at night and say hi to my kids, and none of which know anything about what I did in the day. It's so much more rewarding when you get to turn that around and work with people, and then the collaboration. And the last thing I'll say about mentoring is that I learn something new every single time I mentor someone, because better ideas come from collaboration. And so it's funny, mentoring always is perceived to be a one-way street, and it's just not. I mean, for me, literally, I even so far as the exchanges with clients. Like I'll say, this is what we're thinking of doing, and I was on a call last night, and my client said, well, what about this? And I was like, you know what, that's a great idea, and I needed that sort of feedback. I think the direction was in the right direction. I was confident with my advice, and then there was a twist. Well, that's from a client level. Well, you learn so much more and can gain so much better insight if you're collaborating. And so I think the term mentoring is too one way. I like to collaborate.
Very nice. So, I mean, you and I guess your partner, Jordy, are great mentors. So much contribution to the younger community. And, I mean, when talking to estates lawyers, the public doesn't necessarily know that estates is divided up into at least 3 main categories, maybe more. But you got the litigation, the planning, and the administration. I kind of hang out in the latter 2 of those, and you're one of the rare people who are considered experts, even a certified specialist in estates law, but the experts in all 3 of those. How do you straddle those 3? And I know litigation is the main part, but I want to talk about everything, such a broad expertise.
Well, it's an interesting question, and one that we're lucky enough to get into a specialized area, and you and I both live and breathe that kind of a practice. But I learned early on that to do any one part of the area of practice, it's better to have a deep understanding of the other aspects of it. So I don't draw as many wills as I used to personally, but I was drawing wills early in my career. So I knew about that feeling of intake, and I knew about the feelings of what clients were going through. I knew about what a lawyer should be or shouldn't be, in my mind, to doing in an intake scenario. And then I can impart that into a contentious situation where, sometimes I find state litigators in particular, they get very judgy about the solicitor's side work because they're just looking at it from a critical standpoint after the fact. And it's always 20/20 hindsight. Well, so I spent a lot of time early in my career learning how to run an estate administration, how to do wills, and how to run a lawsuit that was contentious. And by doing that, obviously heavily weighted toward the litigation in my personal practice, I was exposed to all aspects. And it just, the area isn't that big that you can't at least see some of that exposure. But how important is it to, in my view, it's so important to be sitting across the table from someone, if you're litigating over them, knowing, you know what, I did a will where I cut a kid out. And I knew what I did in that situation. And I can judge the behavior like a judge is going to be judging that behavior. So that's part of the reason why I focused so broadly. And I think it's, in my view, my own personal view, is it's a mistake to eliminate any aspect of the estate's bar work to from your practice if you can avoid it. But look, Jordy's a classic. He put his gowns down and he's not going into court anymore, and that's great. But he was running in, doing a few contested passive accounts, doing some of the stuff where you dust the gown off, just to get a sense of how the judge is going to manage things. So it may not work for everyone, and some people are in firms where they exclusively have to stay within their very small box. But that's where I turn around to go to continuing legal education. And I at our firm, I say to people, I want you to go to solicitors seminars. I don't want to hear about state litigation seminars. Those seminars, we can have them at breakfast. And I mean, I'm overstating it. Obviously, some of them are fantastic. But I want you to go and hear about what's an estate administration do, and what efforts take to do an estate administration, just to give yourself enough information to guide your practice.
Mm-hmm. So yeah, I'm on the planning side more, but I try to understand as much as I can from the litigation side as well, like you say. And it's funny, as I would consider myself a relatively younger lawyer, and one of, call it my referral sources, are more senior estates lawyers that decide that they don't want to do, let's say, blended families or cutting out a kid, like you mentioned. And, you know, on the one hand, there's access to justice. Everybody needs a wills and estates lawyer. But on the other hand, certain people just decline to act for certain people, certain circumstances. So, I mean, two questions based on that. Is there any advice about just blanketly avoiding certain cases, certain people? And why do these, like, am I getting tripped up by taking on certain files, blended families, let's say? Or is that a justified policy to reject certain cases?
Well, I think it's a really, really good question, because, you know, the access to justice element of it is so important. It's getting more and more important, certainly outside the GTA especially, where even getting access to a lawyer to do I never use the word simple will, but to do a will is becoming problematic. I would say this. First of all, obviously, personal lifestyle choices prevail, and people want to keep their workload as they see fit, and they don't want to be at night worrying about everything. And but you know, I don't like, when I first started practicing, I took in, you know, small estates, stuff that was going to be hard grinding. And my dad would always say to me, look, you don't get these files because of the easy ones. The easy ones are out there and they're getting done, and they're not getting referred out because they're easy. And so, you know, I chose a path of grinding through some of those more difficult ones. But boy, do you learn. And you're interesting to say to you know, is it justified? Well, of course it's justified to say no to someone. That's your own personal practice choice. But how much you learn when you get into a complex, not even just asset-wise, but just a complex family relationships planning situation. Is stuff that, you know, is knowledge that you can hang on to forever. But it also is what we get, like we, you know, you call it, you've got a spidey sense. Well, the spidey sense comes from the fact that, yeah, I've done 7 or 8 of these, and I saw where the bobbing and the weaving needed to be done. So you know, I'm more of the view of just saying, look, it's, you know, go to people if you need help, ask around, get the assistance you need to get through it. But you know, saying no is, you know, from a business model standpoint, if you're a referring lawyer and you're sending a file out, you don't want to hear about it again. You don't want it to bounce back. And so when I get a file, and I'm obviously going to take it, and then I say yes, and then you take the good and the bad with that. And if it takes a little bit of extra effort or a learning curve on a new area, I got to do it. I got to roll my sleeves up and learn it.
Mm-hmm. So a kind of continuation of that train of thought, that question, is no matter how good a planning lawyer is and how diligent they do and they ask the right questions, is there any foolproof way to avoid litigation, or is it just certain circumstances, the world's going to be challenged?
Yeah, there really, of course, there isn't, in a sense that the problem is, when I'm an old man now, but I'm almost 60 years old, and when I first started practicing, you would be into a will challenge. You had the conventional 5: fraud, lack of a testamentary capacity, undue influence, and so on. Those would be the core challenges. Now they're probably 15 twists and turns and proprietary estoppel and not all of it is fine. It's all good, and it brings with it, it's come from different jurisdictions. The U.S. And in particular, UK brought in proprietary estoppel in terms of brought it forward as a type of claim. So I would say this, that from my perspective, I always say no when I know I don't know it. So if I'm going to get myself into an area of the law that I just simply can't support, or I don't have people around me to support, I'll walk away from it, or I'll make sure I bring in the right team to do it. But, from my perspective anyway, I think the practice of law is extremely complex, but the substantive elements of an estate practice are manageable. And that's why I've enjoyed it so much all my career.
Mm-hmm. So, about the work you do, there's so much that goes into it, but you're dealing with very intense emotions from both sides, sibling, again, emotions that emerge in these disputes. Is there any tip to keep yourself somewhat detached and not involved personally in these cases?
Yeah, it's a tough one because, first of all, I'm empathetic to these cases, and I've done this for now 31 years, and I probably like to think I've heard a lot of the stories, but I haven't heard them all. And every day I'll hear one, I go, whoa, I hadn't seen someone do that before. So I think to that extent that there is a way to manage it. You carry the burdens on your shoulders of the clients, and that's just the reality when they come to see you, certainly in a contentious litigation environment. So is there, you add that to your shoulders. How I manage it personally is I try to be patient, and I try to like anything, I'll let it cycle a little bit, even if it's it's right after the death of a loved one. The emotions are going to be higher, and I assess that in that context. If I'm on a call with the client and things get heated or get emotional on the call, I'd like to let it run its course a little bit and talk it through, a little bit therapeutic in a way, spending the time with the client, working it through, because the truth is you can't feel what they're feeling, but you can at least manage your behavior in what can be a hotly emotional, threatening time for both you and your client. And so I just keep trying to be as patient as I can. And patience has really been what succeeded in keeping the temperature down on these hotly contested situations. But do you take some of this stuff personally? It's, I'd be untruthful to say that I don't sometimes get a little personally involved in files. Of course you do. You learn to enjoy your clients. You like them so very much sometimes. I've got long-term clients even in litigation, but in non-litigation, that they're friends and they're important in my life. And so yes, you tend to gear up some of your emotions on those situations.
Mm-hmm. So it must be difficult to deal with all that. And another aspect to your practice, I mentioned the litigation, planning, admin. The, I guess, fourth aspect, which could tie it all together in a way, is mediation. You're also a well-known, respected estates mediator. I'm trying to get into mediation. I just did a course about mediation and realized how, also intensely emotional it could be, how you have to straddle between these two parties. Can you talk a bit about your mediation experience and a little bit about what it takes to resolve these conflicts?
Sure. So yeah, I love mediating cases if I can, and I guess one of the things that always surprises me. I'm old enough to say that mediation is a brand new area of our practice. When I first started practicing law, mediation was not a thing, literally. I remember graduating from law school at Windsor with our gold medals with Alan Stitt, and a great friend of mine. And he went to Harvard after he graduated and did a mediation master's with the leading mediation training in the world at the time. And we all thought, but what's he doing? I mean, he could be the Supreme Court of Justice, the Canada clerk. He could do anything he wants. And he went to do that. And of course, he was way ahead of the curve and is one of Canada's best mediators. But, you know, I knew once I started to practice law that you're essentially a mediator. And I do feel personally, I think the profession has got a bit lazy on the exchange between counsel to resolve problems. I think we tend to now rely on mediators to jump into the process more than it used to be. We were just forced to get on a call and say, okay, I get that point, but what about this point? And those kinds of discussions. And not to say they don't happen, but I think there's an ability for us to do more of that. And I say to my associates all the time, pick up the phone and create the rapport with the counsel to help take some of the temperature down. But as to my personal mediation practice, I actually went down to the Harvard course. They have a great course down there, pre-COVID, of course. Many years ago, I went down and spent a week getting training there, and it changed my life.
That's the course I just did. Now it's on Zoom, so I just did that course as well.
See, and it's fantastic. It's a game changer, isn't it? Mm-hmm. So that's great. I'm glad that they're still running it on Zoom. You won't. I mean, it's helped my practice immensely, and it's also helped my mediation practice. Again, I think as a mediator, there's two things I always think about when I'm mediating a case. One is that be a good listener, for sure, and empathy is important, but also be a leader, and lead discussions and lead. And at some points, lead your thoughts. There's all sorts of schools of thoughts on how to mediate. My personal style is at some point I will give some of my own views. And that's in part because I think people retain me because they're expecting that at some point. Mm-hmm. And it'll be the same for you as you build your mediation practice. You've got an expertise. People want to know what your thoughts are in the context of the facts that they've given you. But boy, is it my final thought on mediation is that it's such a crucial part of practice, and it has game-changed disputes. I mean, when I started a file in the early 90s on a will challenge, it was a 2.5 to 3 year process. It's now, on average, somewhere between a year and a year and a half. Now, COVID's blown that out of the water a little bit, but we shrunk it almost in half by getting to mediation quickly, using the core facts upon which you need to rely on, and looking for results as opposed to looking for process.
Mm-hmm. It's incredible. It's an important part, and I think it's growing because of the reasons you've mentioned, and it's an important part of the process. Definitely. With some of my previous guests, also estates lawyers, I just to name two, Don Carr and Professor Oosterhoff, I asked them the question, so in your long careers, what has changed? And both said not much, actually. But in the past year, I don't think, that was in 2020 I interviewed them. I think this year they would have a different answer. And I'll ask you the same question, obviously, spurred on by Doug Downey, our Attorney General. There's been a lot of significant changes and perhaps more to come. So can you comment on the changes that have been made? And then we'll get to, after that, what changes you suggest going forward.
Sure. Well, as I say, I think mediation practice changed the practice of contentious matters and non-contentious matters. I mean, a lot of our work, and as I know yours as well, is you get into situations where you have a semi-contentious situation or a semi-contentious administration or a semi-contentious aspect of the estate work. And that's the facilitating the collaboration and mediations changed things tremendously in that regard. Look, we can't shout out Doug Downey enough from his efforts. He's been as important as an Attorney General as anyone, going back to Roy McMurtry days, where Roy brought in profound amendments to the whole area of estates. Doug Downey has focused on some legislative changes, but really focused on process changes. And that's really what I think matters. I would disagree a little bit that things haven't changed that much on the litigation side, even over the last 20 years because of mediation. But I would entirely agree substantively that we really have been in a vacuum substantively for too long. But I think we're moving out of that a little bit. But again, the problem is, and I was on a call recently with a client on a terrible elder abuse situation, and the elder law problems that are created these days, or were always there, but we are completely insufficiently prepared to address elder law abuse in Canada. And it's been that way all through my practice, but it's obviously getting accelerated, and COVID has brought it through the roof. But yet, really, there has been no meaningful progress in terms of streamlining a solution to an obvious elder law environment where abuse may be occurring. And I don't blame anyone who's in the system. I blame the fact that government just isn't paying attention to that issue as a priority. And I will say Doug Downey has brought some priority to the substantive work. But the elder law is a more complicated area because we need some federal assistance to the criminal code as well, and we're going to need some provincial assistance. So it adds another layer of, we need a lot of people interested in it. But I will say that the most recent changes that Doug Downey has brought forward is a welcome. I think the process will ever be it will always continue to get better. The substantive, I have to be realistic. I mean, this has been a priority. This has been a great attorney general. Doesn't always last forever. So we're working hard and with a group of lawyers to try to continue to push forward with opportunities to just see if we can continue to tweak things to keep moving forward. And obviously, substantial compliance, which just came in, is an illustration where all the other provinces almost entirely have created that opportunity for wills, and we finally did. And those are sorts of things, the revocation by marriage, those kinds of changes. Those were, I think, low-hanging fruit, and I think it was great that Doug Downey's brought those in, and I'm sure he's ready to continue, and he said he is ready to continue with this progress, but we'll have to see where the political reality sets in. But we're thankful of the changes already.
Mm-hmm. Nice. So, I mean, you mentioned that there's a lot of need for change as well. Go into as much or as little detail as you want, but what are the top items on the agenda if you were Attorney General today? What would you do regarding elder law or anything for that matter?
Well, elder law is a bit of a pet peeve for me right now, because I think what we have to do is create a situation. Like, the difficulty with elder abuse is that the process is cumbersome. B, the judges aren't equipped to deal with these situations where you're into that gray area of capacity, or you've got one child who is dominating the parent, and the other child has to come in and take steps. The hard and fast rules that are created there, for example, you need to have a fine even capacity to get a guardianship order. Maybe some of those things should be revisited. And quite frankly, there's been some great law reform already on this. The Law Reform Commission, Law Commission of Ontario, and I wasn't on that subcommittee, but worked very hard and has created some really tangible illustrations of how we could move forward with some elder law legislation. Then coming back to the other area, the practices, is that efficiencies are being built into the practice of law, but there needs to be a balancing. I mean, the rules with respect to wills and estates have been around for 600 years, Magna Carta kind of stuff, for a reason. And so I also don't want to be rushing too fast to the finish line on some of these amendments that are being talked about, where I think there is a good reason to keep things sort of the way they are. But here's an easy illustration. I think we're way past the time for wet signatures. I mean, wet signatures on a will is dinosaur time with the technology the way it is. We can prevent fraud, and we can do all of the things that in the 1500s they couldn't. Mm-hmm. And that's why they had to have two people who witness it. I wouldn't mind rushing to that end line on that element of the practice, but and I've spoken to Doug Downey personally about this. I mean, I get that there is some resistance to that kind of a dramatic step. And so what what I like to do is when I see opportunities, and this has come up in certainly with with the legislation, look at other jurisdictions, see what they've done, see where the problems have been created, and try to tweak it to make it fit Ontario. And we've done that with MAID. We can do that with wet signatures. I think those are the kinds of innovation that the public needs, and that we can do, and with comfort and without exhausting the profound importance of these rules, which are around for good reasons.
Mm-hmm. Yeah, there's definitely a lot of room for improvement. Electronic wills, maybe that'll, be joining us in the near future. I want to ask you, Ian, about your immense courtroom experience. I mean, you've appeared at every level of courts. Maybe you can focus a bit on your Supreme Court experience, but what's your feelings or preparation or kind of going into a regular court in Toronto on University Avenue versus a Court of Appeal versus the Supreme Court? How do you approach those appearances differently?
Well, my Supreme Court appearance was life-changing, for sure. And I didn't. It was recent in my career, so I had wished, I'd done it sooner. I'd be a better lawyer for having done it sooner because of what you go through for that experience. I always harken back. My dad, I think, was in the Supreme Court of Canada over 25 times. And in those days, it was just a thing you did. It was just added to the list. So that's another appeal. We're going to walk over there. And so the fact that I got there once was a great experience. And really life-changing. There's nothing more daunting than having that panel, a full panel looking down at you, and you're thinking to yourself, I just scraped through law school. What do I know? Like, this is a bunch of really smart people. And then to the right, you've got 25 clerks who are all gold medalists at all the law schools. So you can't reenact the terror again. But having said that, it was obviously a tremendous experience. But one of the things that I had focused on when I appeared at the Supreme Court of Canada, and now have included in my practice now, is that you at that level, you are just ready to answer questions. They don't care about your pitch. They want you. You can weave your pitch in, but you have to be ready for questions. And I think that's changed my practice, certainly at the Court of Appeal level. And if I ever go back to the Supreme Court of Canada, I'll be ready for that aspect of it. But what it's allowed me to do at the Superior Court level, where I'm at most of 99% of the time, is be anticipating what are the questions in the minds of the judge. They'll give you the time to make your submission at the Superior Court level. But what has helped me is that my focus is now much more fine-tuned on what is bothering the judge. They'll hear the story, I'll get the story in, or they'll have seen the story through the factum and so on. But what would be bothering the judge? And in a sense, what questions would the judge like to ask if they were more like at the Supreme Court level, where they have expectation is that you're just going to get asked the questions? What is going through the judge's mind? And so that's helped me tremendously. I will say it is a different game. I came through over a month-long trial, and right in the depths of COVID, and I'm about to go into another long trial this fall. It is a very different advocacy game on Zoom to do a trial. But I learned enough to get through the first one, and I'll get through this one. Long trials on Zoom is a completely new ballgame.
Just to follow up on that, is it, as efficient? Is it effective at all? Can a trial or a mediation, or whatever the case may be conducted over Zoom, or do you feel, disabled because of that? Limited? Well,
I think mediation, yes, 100%. I actually think mediation is enhanced over Zoom at some level. I'm not as fussed about mediation. I'll mediate over Zoom, almost any time. And when we come back full time, I think there's still a nice tactile element of mediation. As a mediator, I still like to be able to sit them in the room and look them in the eye a little more. But at trial, what in my view is it's good and bad, like anything, right? The efficiencies are there. You can't run a long trial without a team behind you, because you're calling up documents in a pace that is rapid fire compared to at a regular trial where you would say book 6, tab 23, the judge would open it and look at it. Now you're just going boom, document number so and so, boom, boom, boom. So the pacing on the evidence side is much different. But my personal view is it's advantage witness on the cross. It's very difficult to cross-examine on a trial. It's not impossible, and I've had successes and failures, don't get me wrong, but I find that is the tougher skill to develop, and some people are getting better at it than others, quicker than others. But all in all, I mean, it's not about complaining at all, because I don't care. If that's the system, I'll work within the system. It's more about making sure that I personally like to identify where are going to be my personal weaknesses in a Zoom trial. What do I have to build up on? And my personal exposure is getting better at cross on a camera.
Well, there's a lot of room for growth and development there within the whole Zoom framework. Just to shift a little bit, one of my last questions for you is, you speak to lawyers in other areas, criminal law, for example, and they say, don't become a criminal lawyer. If someone was just starting out, graduated law school, got called to the bar, and is deciding whether to be an estates lawyer or a criminal lawyer, real estate lawyer, whatever the case may be, what would you advise them to pursue estates or not? And then follow up to that is once they've made that decision, what kind of advice would you give them to excel as an estates lawyer?
Well, I guess my own personal view is that if I had someone ask me that question, and I do say this from time to time when I'm asked, I always say this, I would become an estate planning lawyer right now. And I say that, and I'm so proud of you and your career, because you have rocketed into this area of estate planning and wills drafting at a professional level that parallels no one, I can tell you, because you had the guts to jump into the area, coming from good exposure to it before, but you had the guts to jump into the area, and so I would want to turn around that question on you on how to succeed, because you have succeeded. But why I say that is this: I do think the profession has lost so many estate planning lawyers to retirement and death and so on, that I think that the area, if you're going to get into estates, that I personally believe the area of growth is estate planning and wills drafting. But I also think it's an area of it's sustainable. You're not in high conflict every day. You have to be ready to be in high conflict every day if you're going to be an estate litigator. And it's hard to know whether or not you want to be in high conflict every day for the next 30 or 40 years when you start your practice. I still love what I do, and I still do 80% of my practice is litigation, so I'm still in high conflict every day, but it's kind of dumb luck. I didn't know I would be. My dad always shied me away from the estate planning work. He didn't think I was well suited for it, and he might have been right. The ability to have attention to detail, and the patience, and the systemizing of your practice, and the ability to be available to clients on a literally a moment's notice, in a sense, like a true corporate commercial lawyer. At the end of the phone, they need you then, and they don't need you in an hour. All of that is very important to be ready for if you're going to get into that area of the estates work. But and I won't say this because I know it, I just feel it, and you can probably answer the question better than I can. I mean, it's got to be more rewarding at some level. Now, look, personally, love litigating. I couldn't be happier when I'm in court. That's what I do and I love. But again, as I say, it might be just dumb luck that I do. And I'm now into my 32nd year of practice, and I still love it. And I hope to touch wood, if I can stay healthy, keep doing it for a long time. But I really think that it's a bit of an access to justice issue. And I think there's also tremendous opportunities to make an efficient estate planning practice a go. And therefore it gives you a lifestyle opportunity that I'm not sure litigation does at the same level, but I don't regret it. I don't say to anybody, don't be an estate litigator, because boy, it's been rewarding for me. So I think it can be rewarding for a lot of people.
Well, I can't deny that my success is directly even attributed to you and Jordan Atin, your mentorship. I'm seriously, when people ask me how I built it, the answer is find a good mentor. Find people who are willing to teach, give you their time. And you and Jordy appearing every week, you should continue to do it because it's immensely helpful. And if people don't know already, the eState software has also been immensely helpful. Being accurate, producing high quality documents. I think every estates lawyer needs to be using some sort of software to make their practice more efficient. If they're not, like I've heard you comment, it's just backwards. It's doing everybody a disservice, themselves and their clients. And I really think the whole world needs to be aware of such technology and adopt it, because that is the future. So that's my answer. Find good lawyers like yourself who are teaching and available, and you can practically emulate. That's really the trick. No one's inventing the wheel. You mentioned the mentorship of your father, and I really advise other young lawyers is to just find good lawyers and try to emulate them and develop a relationship with them. And that's how I do it. And again, I appreciate that you're one of those people, and you should keep it up because it's really a great help to us all.
Well, thanks, Avi. But I will say though, I think it's people underestimate the ability to do what you did in the sense of reaching out and using the resources that are there as a tool for mentoring. Some people say, well, look, I don't know anyone in the area. I don't have any clients. Well, it's all available. And it's a question of putting your head down, doing the good work product, and learning who is out there and learning what resources are out there and who and reaching out to some people. Some people are better at it than others in terms of their mentoring and the sense of availability or interest in doing it. So I appreciate your nice comments about us, and we pride ourselves in the mentoring work that we do. But I do think it's an area of practice that people can build if they put their mind to it.
Mm-hmm. Absolutely. Have a solid foundation and surround yourself by good people, and you can do anything for that matter.
That's right.
Ian, I very appreciate your time here and your wisdom, and I know we've scratched the surface, but I look forward to continuing our discussion and seeing you on the weekly mentorship calls, and continuing to stay in touch.
Well, thanks. This is a real thrill for me and a privilege to be chatting with you, and always glad to see you.
I appreciate it. I look forward to seeing you again soon.
You bet. Take care.
Thank you, Ian.